Good morning, everybody, and welcome to our GMH Stallard Employment webinar. I'm joined this morning by two individuals that many of you will know from GMH Stallard, so Simon Bellum and Abigail Mayno. And this morning, we'll be looking at some of the trickier, but what we have found quite common issues that have arisen with clients as they've worked through workforce planning and redundancy initiatives. Now, hopefully we can provide some of the red flags to you, and you can then make some informed decisions about whether your plans and your projects will work for your business. Now, no webinar is complete that we've done so far without a short furlough slot. So Simon will be providing a very quick furlough update on a couple of issues that have arisen since our last seminar a couple of weeks ago. Some housekeeping as usual. We expect the webinar to last around 50 minutes to an hour. We will have questions from you, hopefully. So if you can submit those questions via the Q&A button, and we'll hope to answer some of those during the course of our webinar. Those that we can't answer during the webinar through time, we will answer them and put our Q&A sheet onto the webinar within the next few days, together with a recording of the webinar as well. We also have a couple of polls throughout the webinar, so if you can participate in those, that would be great. If you're on a smartphone, then please do scroll down to the bottom, because the submit button sometimes is hidden. So let's start with Abigail, who's going to be talking around some of the issues relating to voluntary redundancy, exit incentives, and career breaks as you move through your redundancy workforce planning. So Abby, I'm going to hand over to you. Thank you.
Thanks, Rebecca. I thought I'd dive straight in with seeing how many of you watching have used voluntary redundancy, or indeed are thinking about using voluntary redundancy as an alternative to compulsory redundancy. So we'll just wait for the poll results to come in. It can take a couple of minutes. And I know many of the clients we're speaking to are looking at this as part of a suite of packages in terms of their workforce planning and looking at ways to avoid compulsory redundancies. So while we wait for that, see how many of you are thinking along the same sort of lines. Right, so a split, but a fair proportion of you, 45%, have either used or are considering voluntary redundancy. And of course, there's no obligation to offer voluntary redundancy, but it can minimise the effect on morale of compulsory redundancies in a workforce. The reality is, moving on to the slide, is there's almost always going to need to be an incentive to offer voluntary redundancy, so an incentive for employees to agree to it or to volunteer for it. So the first and crucial question really is what you're prepared to offer by way of a voluntary package. It has to balance being attractive to employees with being affordable to the business. And some offers could look at things like providing enhanced redundancy pay, giving additional months of salary, potentially writing off loans, or gifting company property, so laptops, mobile phones, etc. Do beware the tax considerations with writing off loans or gifting company property. They will need to be reported on a P11D and have Class 1 national insurance contributions deducted. So some of those things in terms of your overall package may have tax consequences to consider. And when considering how to put together an enhanced redundancy scheme, there may be potential for age discrimination challenges if the proposed scheme uses age-related criteria. So, for example, if the scheme disproportionately favours older workers over younger workers. There is an exemption in the Equality Act for enhanced redundancy payments to be made in a voluntary redundancy situation where, in effect, it broadly mirrors the statutory scheme. But if it doesn't and still contains age-related criteria, then if it's challenged, you will need to have be able to objectively justify the use of that scheme and show that it's proportionate. So it's worthwhile thinking about what you're trying to achieve with your voluntary scheme and whether it could potentially adversely impact some groups over others. Now, are you going to be consistent in the way that you offer voluntary redundancy or ask only certain groups of at-risk people? If you're going to limit the offer of voluntary redundancy to some at-risk groups over another, you need to have a very clear reason as to what you're seeking to achieve by limiting the offer. And it may be things like minimising the uncertainty in a pooling situation. Offering just to certain affected areas will undoubtedly cause some workforce tension, but it may also be used as a basis for those individuals who weren't given the opportunity to volunteer for a basis for a challenge to the fairness of their overall process if they consider that not everything was done by you to avoid their compulsory redundancy. And I've put up on the slide control. To keep control of the process and to make sure you don't lose people that you don't want to, or you lose too many people, you should make it clear that when you're inviting applications for voluntary redundancy, that you reserve the right not to accept all applications for voluntary redundancy. Employers can come unstuck without this caveat because they may inadvertently end up in a position where they're bound by the volunteers that come forward that they haven't envisaged or indeed want. And compulsory redundancies or the potential for compulsory redundancies should ideally always be kept on the table because you may not get sufficient numbers of appropriate volunteers. And it really manages the rest of the workforce in terms of their expectations. So moving on, if you're offering enhanced redundancy terms, you'll need to decide whether to make them conditional on those employees entering into a settlement agreement or not. The advantage of having a settlement agreement, as you all know, is that you can be as certain as you pretty much can be that no claims will come off the back of that once it's all signed. You can also have other provisions such as non-derogatory statements, confidentiality, potentially new restrictions if that's relevant or required. So it can be a very helpful way of having a very clear and updated exit arrangement with those employees. The downside are the additional costs in drafting and drawing up the agreement, potentially having multiple solicitors and comments coming back, together with a contribution to legal fees that you'll have to make for the employees who are taking advice. If the numbers are sufficient, you can consider identifying a number of independent firms that you can signpost employees to, and those independent firms may have the benefit of seeing the template settlement agreement that you draw up to provide any generic feedback before it's then given to the individuals. And that the advantage of that is it can hopefully minimise any further comments once they're given out. But of course, the employees would be free to go off panel, if you like, and seek another advisor if they wanted to. If your settlement agreement and part of the benefit to you as an employer is that you would like an effective handover or some key deliverables to be achieved before the individual's exit, then do be aware of the tax issues related to that. If it looks like part of the reason for having a bit of a period of time between offering the settlement agreement and the individual leaving is to undertake a handover or achieve certain things, then part of the compensation could be deemed as a retention bonus, which is a taxable sum. So if that is relevant, then you may want to consider separating out some payment and clearly stating that it will be taxed in order to minimise those issues. And if you do have a long period of time between giving the settlement agreement and the exit date, then you should consider whether it's appropriate to have a reaffirmation agreement, which is an agreement at the end on or around the termination date, where the employee re-signs to waive any claims and to confirm they've complied with the original settlement agreement. And they can be particularly helpful if employees are working their notice and within the business to ensure that any new claims that may have arisen between the original signing and their ultimate exit date have been effectively and validly waived. Although your original settlement agreements will say that all future claims will be waived, the reality is that if they haven't yet arisen and aren't in the contemplation of the parties, then that may not be possible with the original agreement. So do consider that. I'm going to move on to career breaks now, and another quick poll as to whether you would consider giving a career break as an alternative to compulsory redundancy, either offering it as part of a suite of packages, or if the individuals come to you and suggest it as a potential alternative to their immediate at-risk and potential redundancy. We'll just wait for you all to answer that. And certainly we've been having a number of conversations with clients about career breaks, so it'd be really interesting to see whether it's something that you watching have also considered. Okay, so 44% of you yes, 22 no, and 34% unsure. It's very interesting. Okay, so the first and principal consideration when considering whether career breaks are appropriate for workforce planning at this point is whether it's right for your business. Are you effectively kicking the can down the road and potentially storing up issues and costs to be addressed with at a later date? Or do you genuinely feel there may be an upturn and a need for those individuals at a later date? If you do, then they can be a really effective way of retaining talent at reduced costs. And I've put up there traditional or non-traditional, and by which I mean, are you going to suggest a traditional career break, which is one where the underlying employment relationship continues, or more of a non-traditional arrangement where they would resign before taking the career break on a promise, if you like, of there being an opening at the end of the period? Clearly, having them resign has a number of legal advantages, not least they don't accrue statutory holiday. There's almost certainly a break in continuous service, provided there's not an agreement to re-employ them before they resign, other than we will look and see what we have at the time. And they won't have a right to make a claim for unfair dismissal or redundancy pay if their job is no longer available at the end of the career break, if they've properly resigned before taking it. But clearly that's not going to be particularly attractive to the individual. So most career breaks are the more traditional ones where the underlying employment continues, but they don't get paid, they don't have to come to work. But there will be costs to the business associated with it. Holiday will continue to accrue. Statutory minimum, being 5.6 weeks for a full-time employee, will accrue. You can agree that contractual annual leave over that can be waived or not accrue as a condition of the career break, but the statutory one leave will accrue. Continuity of employment will continue, so there may be an additional cost with an additional year's service, let's say, at the end of the arrangement if there's no role for them to come back to. And what are you going to do with benefits? So normally salary and pension contributions will end, but what about other benefits such as private healthcare, permanent health insurance, potentially life insurance cover? They will all need to be worked through and looked at in terms of the cost of the arrangement. And crucially, what's going to happen at the end? So will there be flexibility to extend that career break or to cut it short if you do have roles or vacancies or a need for them to come back? What happens if the role's not there? How are you going to deal with that? And what are their expectations? So that's all really important planning before offering or agreeing to it. And I've put up there, do you need to offer alternative vacancies? So if employees have come to you where they may otherwise have been put at risk of redundancy and suggested a career break, which you've agreed to, do you have to offer them the list of vacancies that you will also offer out to the people that you have that are at risk of redundancy at the same time? Because the only reason they offered or volunteered for the career break was to avoid their redundancy. And I think probably not, on the basis that those at risk of redundancy will have a more immediate and pressing need to be given the opportunity to apply for alternative vacancies to avoid their dismissal. But you can certainly see how an individual on a career break at the end, if their job's not available, may question whether that should have been done. So I hope that's given you a little overview of some of the issues to consider in this section, and I'll hand it over to Rebecca now.
Gail, thank you. We've got a couple of questions that came in prior to the webinar on the registrations. So one of those relates to volunteers. So if we have more volunteers than we need, is there anything that employers should think about when deciding which offers to accept?
Yeah, no, that's a good question. That shows the importance of retaining that ability and control over the process and the ability to refuse any volunteers. Normally, you would retain your better performers. And whatever process you use to decide which ones to retain, make sure that those selection methods aren't discriminatory in any way. That's the key point. The possibility, I think, is to use your selection criteria from any compulsory process that you then move on to, and I think that would be a sensible starting point.
Okay, that's great, Abby. And then a fairly wide question on settlement agreements that you've spoken about. So the benefits or otherwise of using settlement agreements in perhaps trickier redundancy situations, and perhaps what to be mindful of. I know that's a very deep question.
Yeah, we could probably take up the rest of the webinar with that. I mean, if it is a tricky one because of the legal risk, then clearly a settlement agreement can remove those risks if it's accepted. But if it's been challenged because of any discrimination or fairness, then the individual's expectations might be quite high, higher than the company may be prepared to offer. So you need to consider that before embarking on those negotiations, and also bear in mind precedent setting. So if there is a tricky situation or a tricky individual because they're trying to get money out of the organisation and you agree to it, is that going to create an expectation among the staff? We all know there's confidentiality provisions, but the reality is people talk. So are you potentially creating an unhelpful precedent?
So I now want to look at some areas that may arise as part of the redundancy and reorganisation process, and how, when using them, you need to weigh up the longer term consequences against the short term advantages that they may seemingly present to you. So turning first to fixed term contracts and the use of fixed term contracts within the context of seeking to avoid an employee's redundancy. Now, most of you, I'm sure, will have used and continue to use fixed term contracts. We know that they're often used to give flexibility for example, perhaps where demand for a particular post isn't clear and the employer might wish to carry out almost a trial period before committing themselves to offering a more permanent position. Or often they're used to cover long-term absences, perhaps maternity cover absences, or somebody on sabbatical, or possibly long-term sick leave. And in the context of a redundancy process, we have seen employers wanting to use fixed-term contracts to effectively extend an employee's employment. So perhaps otherwise they would have been redundant in their permanent role, but the employer wants to effectively hedge their bets for a little bit longer, even though they're fairly sure that the workload has ceased or is diminishing and will cease. But the uncertainty means that they perhaps don't want to lose that employee, but they do actually want to make some changes to the way in which they contract with that employee. And in those circumstances, an employer might decide to use a fixed-term contract. So effectively what they're wanting to do is make the permanent role redundant and then offer new employment under a fixed-term contract. Now, there are some difficulties with that, primarily because is this really a genuine redundancy situation anyway? Because if you still have the need, albeit for a short period of time, for the work, then you probably haven't satisfied the genuine redundancy reason, and query whether you should really be making the individual or putting the individual's role at risk of redundancy. So there is a potential challenge from an employee who is then offered perhaps that fixed term role, but would perhaps otherwise prefer to have taken redundancy, because they may well say, well, my role still exists. Why are you actually seeking to convert my permanent role into a fixed term role now? So be careful. Some employees may, of course, take the view that, great, I have some security of employment, perhaps for another 6 months, and will then revisit the position then. And that can be sensible because, of course, there can have been an upturn in work, which might mean that the fixed term contract is then converted back into a permanent contract. Or there may be some alternative vacancies that arise within the organisation that the employee is happy to take. So from a pragmatic point of view, providing a fixed term contract solution to an employee that would otherwise be made redundant can be useful, but from a legal sort of technical perspective, it may well be that the employee challenges it and says, well, actually, I'm not really redundant anyway, am I? So why are you wanting to convert me to a fixed term contract? And that moves on to the next point, which is the reason perhaps for wanting to convert somebody as well onto a fixed term contract could be one of cost. So it could be, it's quite an expensive permanent role, and you're wanting that role to be carried out at a lower cost. Now, again, that is fraught with difficulties because under the fixed term employees regulations, an employee who is on a fixed term contract is entitled not to be treated less favourably than a comparable permanent employee doing the same or broadly similar work. So if by reason of their fixed term status, you are going to be treating them differently, then there are risks of potential claims under fixed term employees regulations. And less favourable treatment will come where you have terms of employment which are less beneficial than the permanent role. So perhaps you're reducing benefits, perhaps you're also reducing salary. So you would have to be able to rely on some objective justification as to why you are providing terms that are less favourable under a fixed term contract. And that's going to be quite difficult when the individual who's moved into that fixed term contract is going to be able to say, well, I know what the comparable permanent role is because I used to actually do it. So this is fundamentally unfair that I should be given terms now that are less favourable to those that I was doing maybe a week, a month ago under my permanent employment role. So do be careful about how you approach the terms of that fixed term contract, and it's going to be pretty risky if you are looking at giving them less beneficial terms. You also need to look at what is going to happen at the end of that fixed term contract. So clarity of approach as to how the expiry of the contract is going to work is vital. And a lot of that will depend upon the notice provisions that you put into the fixed term contract. So drafting notice provisions carefully is essential, perhaps to avoiding more, it is essential to putting yourself in a position where you might be paying more at the end of the term than you thought you would. For example, if you have a hard stop expiry date, so let's say 31st of December 2020 is the end of the term, and there are actually no notice provisions. If you don't provide some clarity as to what's going to happen at the end of that term, and the employee actually comes back after the 31st of December because they didn't realise that the fixed term contract had ended, nobody in HR has told them, and back they come in early 2021 and carry on working, then in effect there is an argument that the contract has then been converted into an indefinite permanent contract. Equally, if there are provisions which require notice to be given before expiry and that notice isn't given, again, there is a risk of run over of the contract, and the employee then just continues as an indefinite employee on a permanent contract. And then if you then need to make redundancies in respect of what that individual is doing, you are going to be subject to requirements to make statutory redundancy payments and also give notice as well to end the contract that otherwise should have ended either on that hard stop date or could have ended when you wanted it to had you served the appropriate notice. So do be careful about what happens at the end of the term. And also you need to be aware that fixed term employees are entitled to be notified of any permanent vacancies. So as their fixed term is coming to an end, it's something that needs to be made aware as to whether there are any vacancies. And obviously, if that fixed term employee wants to apply, then you need to make sure that they have appropriate provision to do so. So moving on to redeployment. Now, obviously in a redundancy situation, we all know that there is an obligation to look at alternatives to dismissal, and that includes looking at any suitable alternative vacancies that may arise, and indeed looking at any alternative vacancies, because it's always dangerous to consider that an employee might not take a particular role. And that moves me on to the subject of bumping, which is a scenario within redundancy that hasn't been particularly either popular or particularly frequent in previous redundancy exercises that I've been involved in. But I've noticed over the last few months, there has been an increasing number of employees that are asking whether the employer should consider or would consider bumping. Now, bumping is a scenario where the employee whose role is at risk of redundancy is able to ask whether they can take another role within the organisation that is not one that is at risk of redundancy, and effectively bump out that employee in the non-at-risk role, and the at-risk employee then takes that other role as an alternative. Now, it usually occurs where an individual perhaps is in a more senior position, perhaps they're a manager and they've been supervising a team of 10 people, and it's only the manager role that's been placed at risk of redundancy, so the other 10 direct reports are all safe. The manager, however, will say, I can do any of those roles. I've done them before. I've been here a long time. I have the skill sets. I don't mind taking a salary reduction. I don't mind a loss of status. I just want to keep employment. And that's the sort of classic bumping situation where, as the employer, you do need to consider it, even though it probably creates a degree of tension in respect of employee relations. And it usually means that the employee that's potentially going to be bumped out hasn't been involved in the redundancy consultation from the beginning because they were never at risk. And you therefore need to start a redundancy consultation with that employee who is potentially going to be bumped. Now, what's interesting about bumping is that although there isn't an obligation to accept an employee's request for bumping, it is something that the tribunal will take into account in considering the fairness of the redundancy. And what tribunals have also said is that they won't always expect the employee to raise it first. There will be situations where they will expect it's fair for the employer to raise the possibility of bumping. So you need to apply your mind to it, and you need to work through whether it's something that is a viable alternative to that at-risk employee's dismissal. So it's something quite complicated, and we certainly would suggest in bumping situations that you do take some advice about that. The other alternative to redundancy that we have seen on the increase is whether secondments can create an alternative, even if it's a temporary alternative to a redundancy dismissal. So that might be an internal secondment. So there may be another department that requires some more resource on a temporary basis. And rather than perhaps offering that position or that temporary resource in another department as a permanent alternative, it could be offered as a short-term secondment, and then you can reconsider the position of the original redundancy during or at the end of that secondment. You could also look at secondments externally. Maybe there are clients or customers that would value the skill sets and they themselves need extra resource, and therefore there could be opportunities for external secondments. So think about those, and certainly if the at-risk employee suggests it, make some inquiries. And then if the secondment is a viable alternative, you really do need to then make sure that you have, for an external secondment, a tripartite agreement with the employee, with yourself as the employer, and then with the host company who's going to be providing the secondment, because the employee is likely to be subject to their policies and their processes during the term of the secondment. Also, don't forget, when somebody's on a secondment, don't adopt the out of sight, out of mind approach, because they remain your employee, and particularly if they've been at risk of redundancy and you're not sure what's going to happen at the end of that secondment, you need to keep in touch with them. You need to make them aware of anything that's happening within the business, and that includes any alternative vacancies. So bumping and secondments might provide a viable alternative to an immediate redundancy situation for you. Consider, obviously, if any alternative offers are accepted, you have the statutory obligation to make those offers of alternative vacancies on a statutory trial period of 4 weeks. Now, many employers don't feel that the 4-week statutory trial period is sufficient to work through, either for themselves or for the employee, whether that alternative role is actually suitable and whether it's going to be a viable alternative. So if you are going to extend the 4-week statutory trial period, make sure again that you have a very clear agreement with the employee as to the period of extension. What's going to happen during that period of extension? So are there going to be review periods? perhaps on a weekly, bi-weekly, monthly basis, but don't just extend a trial period and then wait until the end of it and either then tell the employee, sorry, but it didn't work, or wait for the employee to then tell you it didn't work. Again, you need to maintain, good communications and put in place good review processes during that trial period. If at the end of the trial period, things haven't worked out, if it was a statutory trial period, the employee is going to be entitled to be treated as having been made redundant as at the end of the period when the old role effectively disappeared. So they'll be entitled to everything they would have been had they been made redundant and not taken the trial. If you have an extended trial period for an alternative vacancy, and let's say that you had offered an enhanced redundancy scheme, as Abby had been talking about earlier, you also need to make it clear whether that enhanced redundancy payment scheme is still going to apply as well at the end of a longer trial period. So you don't want to be in the situation where 3 months or 6 months down the line, where there's been a trial period, you are then having a squabble with an employee about whether they are still entitled to the enhanced redundancy that they might have got at the end of their old role had they not taken the new the new job on a trial period. And then the final point on redeployment, which I think is useful to consider, is often we see employers just doing a side letter when somebody takes an alternative vacancy. So a side letter just setting out what their new role is, and with flags in terms of perhaps the new salary and any new financial benefits. It's worth, however, considering whether you actually issue a comprehensive new contract of employment rather than just a side letter, because you may want to insert new restrictive covenants. So if it's an alternative role that's quite different, restrictive covenants will need to be considered, and those will need to be fit for the purpose of the new role. So it is a good opportunity to have a full-on refresh of terms of employment when an alternative role is taken. And also, don't forget that role will need new objectives and support with regards to how those objectives are going to be achieved. And then finally, moving on to rehiring scenarios. So there's just a few points I want to mention in respect of considerations when you may be in the fortunate position of being able to bring staff back or being able to advertise vacancies again relatively quickly. Now, rehiring brings about a number of issues with regards to whether statutory and contractual redundancy payments should be repaid. So in a scenario where you've let somebody go, maybe they're going on the 31st of July, and then perhaps by the 1st of September, you are in that fortunate position of being able to contact them and say, we've had an upturn in work, clients have come back, customers have come back, we actually really need you back into the workplace. Would you come back? And they say yes. Now, can you require them to pay back their redundancy payments? Now, with regard to statutory redundancy payments, you shouldn't be asking for those to be repaid if you rehire an employee, because an employee is entitled to keep those statutory redundancy payments even if they are brought back into the business relatively quickly. However, when the employee receives that statutory redundancy payment, that has the effect of breaking continuity of employment for the purposes of the statutory redundancy scheme. So if they're made redundant again, maybe 6 months later, unfortunately you find that work has tailed off again, they won't be entitled to statutory redundancy pay for all of their period of previous service, because the payment of the first statutory redundancy payments has broken continuity for the purposes of the SRP scheme. So they're only going to be entitled to any statutory redundancy for the subsequent period of time post rehire. The position is different for contractual redundancy payments or for enhanced redundancy payments that you make, because that is your decision as to whether you rehire them and seek a clawback of those enhanced redundancy payments. So that will be part of your negotiation with them on the rehire, but you can absolutely ask for those payments back. And many employers take the view that if a rehire takes place within a 6-month period, then they'll be asking for those enhanced redundancy payments back. If it's after 6 months, then actually the employee can keep those redundancy payments, and the likelihood is that the employee's probably spent those redundancy payments, so it would be pretty harsh for a clawback. The next issue is beware the consultancy trap. Now, what I mean here is that you've made somebody redundant, but you actually do realise that you need some sort of ad hoc cover. Maybe you need their skills, but not on the same basis as when they're in the permanent role. So you have a conversation with them about them coming back as a consultant. Now, the difficulties here are that they come back as a consultant, and for all intents and purposes, they're probably doing the same work in a similar way, and to the business, they will look like an employee, despite the fact you probably issued them an agreement which is headed consultancy agreement. So you really need to be careful about the employee status issues if you're bringing people back as a consultant, and you really do need to look at, whether you are actually bringing that person back as an employee. Perhaps there wasn't a genuine redundancy in the first place. And the arrangements on which you bring them back, because the last thing you want to do is to bring somebody back and then to have an employee status, and again maybe 12 months later you're having to look at some turn off of that consultancy arrangement, and that consultant turns around and says, well, actually I'm an employee, and also there was no real break in employment, in continuity of employment, between my permanent role ending and you then bringing me back on an ad hoc basis. So do be careful about the use of consultancies after redundancies have happened. New vacancies, if you notify individuals of new vacancies, are you going to notify all of the employees that you made redundant perhaps in one batch? Or are you just going to pick up the phone and make one individual aware that a new vacancy has arisen? Now, if you have promised people when you made them redundant that you're very sorry that they've got to go, and you'll be in touch if there's any new vacancies, any opportunities, you'd love to see them back, and you then don't do it, and you do opt just to pick up phone to one person, then you're going to risk some fairly disgruntled ex-employees challenging you and saying, why have you afforded the opportunity to just one individual for this new vacancy when actually we were all skilled and qualified? So there may be some challenges on a discrimination ground that you haven't perhaps afforded opportunities to others for some discriminatory reason, but even if it's a non-discriminatory reason, you're still potentially going to have some disgruntled employees who might then be looking for some flaws in the process to bring unfair dismissal claims. And if you are advertising a new vacancy which looks suspiciously similar to one that you have made redundant, you're also going to have challenges as to whether that role that you made redundant was actually a genuine redundancy. So the timing of when perhaps you do advertise a new vacancy is something that you need to consider. So we know that employees have the right to bring unfair dismissal claims within 3 months of the date of their dismissals. If you're offering out a new vacancy that looks similar to one that's been made redundant within the last 3 months, that redundant employee is likely to challenge you and say, was that ever a genuine redundancy? And if it was, why aren't you actually picking up the phone to me and asking me if I want to come back? So be really careful about the timing of any new offers that are very similar to old roles. So thank you very much. I'm going to hand over to Simon, and he's going to talk through some issues relating to maternity considerations, notice period considerations, and also a very quick furlough update on a couple of matters that have been clarified since our last flexible furlough webinar. But thank you.
I'm going to very briefly mention furlough, but then I'll be talking about some particular issues that arise in relation to employees who are on maternity leave, and then talk a little bit about how we deal with notice periods, because there are always some exciting options as to how you're going to be dealing with notice periods when it is necessary to terminate the employment. So just a quick recap on furlough. Two interesting points. First is that there's been a lot of discussion as to whether notice pay is covered potentially as part of what you can claim under the scheme. And it's now been clarified that where an employee has been on furlough and is on furlough, and their employment is brought to an end and they're given notice, then the notice pay that the employer pays them can be recovered as part of the wages cost under the scheme. So that simplifies things for employers. Excuse me. The other interesting announcement by the Chancellor was the February furlough bonus. So what the Chancellor has said is that where an employer takes back an employee who's been on furlough and keeps the employee in employment until the 31st of January, the employer will receive a payment of £1,000 in respect of each employee that's taken back on. So that's clearly something that you'll want to factor into your workforce planning. Okay, well, moving on to some particular issues that arise in relation to employees who are on maternity leave. I think the first thing to say is that communications are vital. There's two obvious reasons. One is that anybody who's on maternity leave is entitled to know what's going on with their job. They're entitled to know about potential changes and indeed risks to their role. And secondly, from a legal perspective, if you fail to consult with an employee who's on maternity leave, then that's discriminatory. So make sure the communication is strong. One tricky issue which arises very often is the question of whether or not the employee who is on maternity leave has a priority entitlement to any vacancy which might exist within an employer. So the short answer is yes. If an employee is on maternity leave, and whilst they're on maternity leave, their position becomes redundant, they are automatically entitled to be offered any vacancy which exists within the employer on suitable terms. One obvious point to make is that if there are no vacancies within the employer, then the issue goes away. They can't be offered something which doesn't exist. One of the trickiest things is if you have an employee who's on maternity leave, their role is redundant, there is a vacancy, they're entitled to be offered that vacancy as a priority over other people who are being made redundant or who are at risk of redundancy. But obviously then, because they're on maternity leave, they're not able to start in that vacant role. And it's clear that the employer in that situation is under an obligation to engage temporary cover whilst the employee remains on maternity leave, so that they can then take up the post once their maternity leave comes to an end and they can go into that vacant position. Keep in mind the impact of maternity and pregnancy in relation to redundancy selection criteria. Make sure that an employee who's on maternity leave or has been on maternity leave isn't adversely affected. So as an example, if absence is one of the selection criteria that you're going to apply in any selection process, you need to discount any absence that might be pregnancy related to make sure that somebody who's been on maternity leave or who's been pregnant isn't disadvantaged. And then the other thing I think it's always worth thinking about is keep in mind that it's possible to extend the maternity leave period with agreement, and that may be a route towards avoiding compulsory redundancies. Right, I'm now going to move on to notice periods. And there's three basic options when it comes to notice. The first is the orthodox approach, which is to give an employee notice and to require them to work that notice out and to pay them as normal during the notice period. The second option is to give the employee notice, to pay them as normal, but to tell them that they're not required to attend at work during that notice period, which is the concept of garden leave, which you're probably familiar with. And then the third option is to say to the employee, right, well, yes, you are entitled to notice. However, we're not going to give you notice. We're going to bring the employment to an end immediately. And we're going to make a payment in lieu of notice, a PILON, which is a financial payment which is equivalent to the salary and other benefits that they would have enjoyed during the notice period. And the employment comes to an end immediately and they get that payment in lieu of notice. So before I look at each of those options in detail, there are a few general points to make. The first is that you can decide what approach you're going to take on a case-by-case basis. You're not obliged to adopt a consistent approach for all employees. Another point that's worth making is that notice periods can be changed by agreement. I emphasize it is by agreement. And there can be circumstances where it suits the employee to leave early and it suits the employer to allow the employee to leave. So you can curtail the notice period if you want to. There are some cash flow implications in relation to the choices that you make, which I'll talk about in more detail, but that can be an important factor in deciding which path you're going to take. And then probably the most important thing is that the contract of employment may restrict you in terms of the options that might otherwise exist. So let's look at the first route, and that is to say to the employee, right, we're giving you notice, you're required to work your notice, and your employment will come to an end at that notice period. So if we move to the next slide, yeah, the first point to make is that if you give an employee notice, then the obligation to consider alternative roles continues to apply throughout that notice period. So you might get to within a couple of weeks of the end of the notice period, a vacancy that arises, then there is an obligation to discuss that vacancy with the employee who's been made redundant. A couple of obvious points to make about employees who are asked to work their notice period, and that is the risk of disruption to colleagues and to the business. Quite often an employee who's been made redundant will be disenchanted, and you've got to think about the implications of asking them to return back to the workplace. Flip side of that is that if you have an employee who's cooperative, it could well be very beneficial to have the employee working out their notice to help secure an orderly handover of duties to anybody else who's taking on any of the tasks that the employee undertook. So I think the message there is you have to weigh up the individual and the individual situation and work out, okay, well, are we better off having the individual within work, or is it too dangerous? Holidays will continue to accrue during the notice period. Employees can be asked to take their holiday during the notice period. Remember, you can require an employee to take a holiday during a notice period by giving the required period of notice to the employee. Benefits, car allowances, private health cover, all those things carry on applying during the notice period. And then in relation to post-termination restrictions, say you've got a 6-month restrictive covenant, then that will begin running from the end of the notice period. Okay, so moving on to the second option, which is to put the employee on garden leave. So again, the employee is receiving their notice, but they're just not asked to attend at work during that period. And you might ask, well, what's the point of this? What's the benefit to it? And it's usually used where you don't want to have the employee within the workplace, perhaps because some of the factors that I've talked about. But equally, you don't want them to be free to go off and work elsewhere, set up their own business in competition, join a competitor, etc. So what you're saying to the employer is, well, we don't want you coming in to work for us, but you can't work for anybody else, you just stay at home. It is important that the contract of employment permits this. If it doesn't, then you're going to need to get the employer's agreement to go on garden leave. Keep in mind the fact that the employee is off the radar, as it were. They remain an employee, but you've got limited control over them because they're not in the workplace. And then in terms of restrictive covenants, sometimes contracts of employment will say that any period of a restrictive covenant is reduced by any period that the employee spent on garden leave. So if you've got a 6-month restrictive covenant and the employee was on garden leave for 2 months, then the period of the restrictive covenant will be reduced by those 2 months, so it'll only be 4 months. And then the final option is to think about a payment in lieu of notice. As I say, in this scenario, the employment ends immediately and the employee receives a lump sum payment in compensation for their contractual entitlements for the notice period. Again, it's important to look at the contract of employment. You can only do this if the contract says that you're entitled to do it. And you might say, well, does that really matter? You know, if the employee is going to be paid in relation to all their contractual entitlements, are they going to complain if their employment was brought to an end early and they received a lump sum? They might not complain, but the important thing is that if there are restrictive covenants within the contract of employment, and if you terminate the employment without notice and by making a payment in lieu of notice, and there's no contractual entitlement to do that, technically you're breaking the contract of employment, and that means that the restrictive covenants lapse. So if you've got restrictive covenants that you want to rely on, and you're thinking of making a PILON, then make sure that the contract says that you're entitled to do that. Another knotty question is, how do you calculate the PILON? Is it just basic salary, or is it basic salary and any other benefits such as car allowance, etc.? Now, the answer is that in calculating the payment in lieu of notice, you do have to include all those other benefits unless the contract says otherwise. Sometimes contracts and PILON clauses state that any PILON will be calculated by reference to basic pay only. And if it does, you're lucky, you can follow that, but otherwise you'll need to include any other benefits in the calculation of the PILON. Sometimes employers are worried about the prospect of the employee receiving a lump sum payment reflecting, say, a 3-month notice period, for example, and then the employee goes off and finds fresh employment within a couple of weeks, which means that they've enjoyed a windfall. One way of guarding against that is including within the contract of employment a provision that a PILON can be paid by way of instalments, and that if an employee does find alternative employment within what would have been the notice period, then they have to give credit for any other income that they earn. Now, as I say, you can only do that and take advantage of it if the contract permits you to do it. The final point in relation to PILONs is keep in mind that the employment contract comes to an end immediately. And that means that the obligations under the employment contract come to an end immediately. So, for example, the employer's obligation to look for alternative vacancies for the employee, that ceases. But the flip side of it is that any restrictions in terms of what the employee can and can't do, their duties of confidentiality, etc., they all come to an end straight away. So you need to keep that in mind.
We've got a couple of other questions that came in on the webinar registrations. One of those relates to settlement agreements in terms of, sorry, it relates to redundancy payments, so and enhanced redundancy payments. And this is a question for Abby. So would it be fair to pay a a percentage of employees' salary, so in effect a lump sum percentage of salary, as an enhancement, as a redundancy payment, taking into account the statutory formula and age discrimination issues for redundancy payments?
Yeah, thanks, Rebecca. The answer is yes, potentially. It always has the potential of indirectly favouring older, longer serving workers who potentially and typically would have a higher salary. But if you can justify it, and you probably can, as an equitable way of making a one-off payment, then it may well be the fairest way that the organisation can consider. And in principle, I think it would be okay.
Okay, thank you. We're coming up to 11 o'clock. The questions that we haven't answered, I will ensure we put a Q&A up on the website with all of your questions, both the webinar registration questions that were submitted and the questions that have been asked throughout this session. But I'd like to thank everybody for joining us this morning, and I do apologise once again for my sound technical issues, and maybe taking the laptop into the repair shop. But thank you for joining us. We will be taking a break from our fortnightly series of webinars, and we'll be back with those in September, possibly perhaps on a monthly basis, apart from we have one very special webinar in mid-August, which will be dealing with the reformed points-based immigration system. So Adam Williams from GMH, our immigration specialist, will be making sure that you're ready for 2021 and working through how you are going to employ migrant workers from next January in the post-Brexit world we're all looking forward to. So all that remains is to say thank you very much. Thank you for joining not just this webinar, but all our webinars over the last couple of months. Have a super summer and stay safe, and we look forward to seeing you very soon. Thank you. Goodbye.